Hello, my name is Kayla Thomas and I am an HR advisor with TPC Vision. Our Vision team provides HR managed services to support the needs of our clients. We have put together the following slides to explain furloughs and layoffs during this coronavirus pandemic. We want to thank you for taking the time to listen to our webinar today. We are here to support you as we all work through this together. This recording is being done on March 25th, 2020. So please note that if you are listening to this at a later date, that the information outlined in the presentation may be updated. Please visit our website to reference the most up-to-date information regarding COVID-19. As a legal disclaimer, we would like you to know that this communication and any accompanying documents are intended for educational and informational purposes only. We hope that you will learn a lot today. We are not attorneys, and the information provided today should not be construed as legal advice. If you are seeking legal advice, you are encouraged to consult an attorney. The purpose of today's presentation is to explain the pros, cons, and best practices for implementing furloughs and layoffs as a result of this COVID-19 crisis. Today we are going to talk about the differences between furloughs and layoffs, the pros and cons of implementing furloughs, the pros and cons of implementing layoffs, and best practices for both furloughs and layoffs. We will also have a short Q&A session. Let's start off with a few definitions. First, a furlough is defined as a temporary reduction in hours of work or weeks of work. Situations might include an employee or group of employees work only 10 hours in a week, employees work every other week, or the company closes for 2 weeks. It usually involves an estimated return date and time frame for the furlough duration. Alternatively, a layoff is a separation of employment, potentially with the intention of rehire. Employers with 100 or more employees should review their requirements under the WARN Act. Under the WARN Act, a temporary layoff means that the employer expects to rehire the employee generally within 6 months. A permanent layoff means that an employer does not have an anticipated rehire date. Now let's look at a comparison that shows the differences between layoffs and furloughs. Furloughs are meant to be temporary. Employees are expected to return to work when the organization is ready, whereas layoffs result in a separation of employment. During a furlough, the employee remains employed with the company. However, during a layoff, the employee is no longer employed with that company. A furlough, again, is meant to be a temporary arrangement, and a layoff may be temporary, but it is most likely permanent. A furlough usually results in a temporary reduction in hours of work or weeks of work, and during a layoff, no work is performed due to the termination of employment. Exempt employees are paid for full days or full weeks that they work with certain specific specifications and restrictions. And non-exempt employees are only required to be paid for the hours that they work. Now, during a layoff, no pay is due to the employee because a termination has happened. However, you could offer a severance package to that employee. Moving on to paid time off. During a furlough, employees can use paid time off benefits such as vacation, PTO, etc. to offset their income during a furlough. As for a layoff, sometimes paid time off benefits may be paid out at the time of termination, but that depends directly on your company's policy. Let's take a look at health insurance. During a furlough, you want to make sure that you refer to the health plan document, your ACA measurement and stability periods, and/or contact your insurance broker to determine if your health insurance benefits continue or if COBRA or state continuation will be triggered during that furlough. Now, with a layoff, the employee may be eligible for COBRA or state continuation coverage after they are laid off. Moving on to unemployment. During a furlough, eligible employees are able to apply for unemployment in certain states, and in some states, the waiting period may be waived. Make sure that you check with your state-specific unemployment office to understand those circumstances. Now, during a layoff, employees are eligible to apply for unemployment benefits. Okay, let's talk about the pros and cons of furloughs. Starting with the pros. Furloughs allow employees to remain employees of the organization, and the organization actually avoids completing layoffs. Furloughs allow employees to also continue to work as needed by the employer, such as a reduced work schedule or alternating work weeks. And this is both beneficial to the employee and the employer. Employees may be eligible for the Emergency Paid Sick Leave Act or the Emergency Family and Medical Leave Act expansion during the weeks that they are not furloughed. Please note that we are still seeking further clarification to determine how and if employees may be eligible, and we will update our website as soon as we get that guidance. Please note that employees can draw both unemployment and emergency leave pay at the same time. Furloughs also give employers the flexibility while still possibly providing employees with optimal pay and benefits, as well as retaining those employees. It also reduces your rehiring needs, and it often saves compensation costs for employers. Now let's take a look at a few of the cons. The employer would need to collect the employee's portion of health insurance premiums, or they may elect to cover the full premium amount of the health insurance benefits. If COBRA or state continuation is triggered and the employee and/or qualified beneficiaries are eligible, the employer will need to ensure that the paperwork and the election forms are provided to the employee. Now, employees who were not furloughed may need to take on additional work, and returning workers may feel an overload whenever they return. So you just want to keep that in mind when you're considering doing a furlough. Furloughed employees may seek additional work elsewhere, and they possibly could not return to your organization. This may cause you to lose high-performing employees. Also consider that it may take time to get your organizational productivity back up and running to your previous levels before implementing the furlough. Also, please note that interrupted work may cause a disruption in innovation and continuous improvement. Furloughs could result in possible lowered morale for employees. And when implementing a furlough, you have to be cautious because employees may fear that layoffs or that the furlough may not solve the problem in the long run. If a furlough is unpaid and they are unable to seek additional means for income, the employees will likely be stressed out about money. So just keep those thoughts in mind as you guys are going through and deciding what to do. Okay, so we talked a little bit about furloughs on the previous slide, so let's talk about layoffs now. We'll take a look here at the pros and cons of implementing layoffs. Starting with the pros. Employers could elect to continue to contribute towards the cost of their health insurance premiums for COBRA or state continuation. It also reduces the overhead costs associated with payroll and benefits so that the organization can continue to operate. Also, when layoffs are conducted based on performance, it helps your organization ensure that you retain high-performing employees. In a positive light, this could actually lead to improved morale and higher productivity in your workplace. Keep in mind that when conducting layoffs when they are based on seniority, it ensures that your organization retains experienced employees. On the flip side, you may also lose some high performers if you solely base your layoff decisions on seniority. Now let's take a look at some of the cons of implementing layoffs. Your COBRA or state continuation coverage is usually expensive for individuals due to the loss of employer cost sharing. It may increase the workload of remaining employees in your organization. It may cause a decrease in employee morale. Employees would not be eligible for the emergency paid sick leave and the emergency family and medical leave expansion benefits if they are laid off. So keep that in mind as you guys are trying to make these decisions before April 1st. This also may prompt remaining employees to start seeking employment elsewhere due to their uncertainty with your organization. It may negatively affect the reputation of the company. It may result in a decrease in organizational productivity, customer service, efficiency, etc. If applicable, it could result in additional costs in severance packages and rehiring new employees in the future. So even though right now you may be implementing layoffs to save cost, keep in mind that additional costs could be incurred in the future. It may also lead to possible legal ramifications if the employee claims that they were laid off due to discrimination, harassment, or unlawful termination. As we discussed earlier, please also keep in mind that employers with 100+ employees should review their requirements under the WARN Act. Okay, now let's talk about a few best practices with furloughs. If you guys decide to implement a furlough, please keep in mind best practice number 1. You're going to want to communicate with your employees clearly. You're going to want to make sure that your communication with employees is clear and consistent. And you also want to make sure that it is documented in writing. Please make sure that you communicate the furlough as a team effort to sustain the organization and your culture. Best practice number 2. Make sure that you enforce a no work rule. Ensure that you are enforcing that no work rule during the furlough. All non-exempt employees must be paid for all work performed for the company, and exempt employees must be paid according to the FLSA guidelines. A good way to make sure that you ensure that the no work rule is implemented is removing employees' emails from their phones and not allowing them to take their laptops or any other type of work home with them during the furlough. Best practice number 3, consult an attorney. To ensure fair and legal furlough practices, make sure that you consult with an experienced attorney. Make sure that your organization's actions with regards to furloughs are legal, ethical, and compassionate. Now, let's talk about the best practices for implementing layoffs. If you guys choose to implement a layoff, please remember these 3 best practices. Best practice number 1, make sure that you show compassion. How you treat people really matters. Be kind and dignified to the people who are laid off and as well as to the people who remain within your organization. Make sure that you give employees the news in person and in private. Best practice number 2, give a severance if possible. If possible, offer your laid off employees a severance package. Severance pay is usually equivalent to a week or 2 of pay for each year of service. It can also be viewed as a thoughtful gesture during these tough times for your employees. Best practice number 3. As we talked about with furloughs, make sure that you consult an attorney. You want to make sure that you, again, ensure fair and legal layoff practices. So make sure that your organization's actions with regards to those layoffs are ethical, legal, and compassionate. As we talked about earlier, you want to make sure that you communicate clearly and that you show compassion to your employees whenever you are implementing a layoff. On this slide, you're going to see a few talking points for implementing layoffs with your employees. Remember, make sure that you are sincere when you are giving the news to your employees. I won't go through all of these different examples, but just to highlight on a few. As an example, you could say, "We hope that you and your family are doing okay in the face of these unprecedented challenges caused by the COVID-19 pandemic. As you know, in order to slow the spread of the virus, various government offices have ordered many businesses to stop providing all non-essential services, and this has negatively affected our business." Make sure that you are honest and truthful with your employees. Explain the situation as to why you have to make this decision for your organization. Make sure that you thank them for all of the hard work that they have done for you and your organization. Be apologetic. For example, share that you are sorry that you have to share this news, but you encourage them to persevere. And remind them that together you guys will get through this. Now let's take a look at some of the talking points for retained employees within your organization. So these are going to be the employees who remain at your organization who were not laid off. For example, you could say, "Each of you is being retained and will keep your job to help the leadership team run the business in this smaller scale operating environment." Make sure that you show your appreciation to them and be sincere again when talking to your employees. Make sure that you communicate that you appreciate their commitment and dedication during these difficult times. And give them the notice. As you would expect, several of your coworkers will be laid off out of business necessity. We will be talking to them shortly to explain how the downsizing will affect them. Make sure you remind them to stay safe and stay well. And again, remind them that together we will get through this. Now we are going to move into the Q&A session of this presentation. We have put together some of the most common questions regarding furloughs and layoffs. Question number 1. Is it legal for an employer to reduce the wages or number of hours of a non-exempt hourly employee? Well, the FLSA requires that all covered non-exempt employees receive at least the applicable federal minimum wage for all hours worked. In a week in which employees worked overtime, they must receive their regular rate of pay and overtime pay at a rate not less than 1.5 times the regular rate of pay for all overtime hours. The Act does not preclude an employer from lowering an employee's hourly rate, provided the rate is paid at least the minimum wage, or from reducing the number of hours the employee is scheduled to work. Also, please note that some states have special requirements for advance notice of pay reductions. Missouri is one of those states. So please make sure, if you are an employer in Missouri, that you do provide your non-exempt employees and exempt employees a 30-day notice if you are going to reduce their rate of pay. If you do not do so and the employee provides you a letter, you may be subject to a $50 fine. Question number 2. Does an employer need to pay an hourly employee for a full day of work if he or she was scheduled for a full day but only worked a partial day due to lack of work? Well, the FLSA does not require employers to pay non-exempt employees for hours that they did not work. Question number 3. Can an employer make a prospective reduction in pay for a salaried exempt employee due to the economic downturn? An employer is not prohibited from prospectively reducing the predetermined salary amount to be paid regularly to an exempt employee during a business or economic slowdown, provided the change is bona fide and is not used as a device to evade the salary basis requirements. Such a predetermined regular salary reduction, not related to the quantity or quality of work performed, will not result in the loss of the exemption as long as the employee still receives, on a salary basis, at least $684 per week. On the other hand, deductions from predetermined pay occasions by day-to-day or week-to-week determinations of the operating requirements of the business constitute impermissible deductions from the predetermined salary and would result in the loss of the exemption. The difference is that the first instance involves a prospective reduction in the predetermined pay to reflect the long-term business needs, rather than the short-term, day-to-day, or week-to-week deduction from the fixed salary for absences from scheduled work occasioned by the employer or its business operations. This is all according to the DOL. Question number 4. Can an employee still be on call or performing work at home during a furlough day? Whether on-call time is hours worked under the FLSA depends upon the particular circumstances. Generally, the facts may show that the employee was engaged to wait, which is work time, or the facts may show that the employee was waiting to be engaged, which is not considered work time. For example, let's say you have a secretary who reads a book while waiting for direction, or a fireman who plays checkers while waiting for an alarm is working during such periods of inactivity. These employees have been engaged to wait. An employee who is required to remain on call on the employer's premises is working while, quote, on call. An employee who is allowed to leave a message where he or she can be reached and is not working in most cases while on call. Additional constraints on the employee's freedom could require this time to be compensated. Employees who perform part or all of their normal job duties during a furlough day are working while performing such duties and as such must be paid. Question number 5. What things should I be considering when implementing layoffs or furloughs? Number 1, you need to consider the WARN Act, as we've talked about a few times throughout this presentation. Employers have the right to implement layoffs. For employers with over 100 employees, the WARN Act does apply. These employers should review any requirements that they may have under this act and/or consult with an attorney to determine any expectations due to the public health emergency that we are currently in. Please note that some states may also have a mini WARN laws or other similar requirements that may apply as well. So please check with your certain states to determine these laws. Question number 5, continued. Also, make sure that you think about the FLSA, as we've talked about in a few of the questions earlier in the presentation. Please note that employers must be careful with reduced work schedules during a furlough, and they must ensure that they are following wage and hour laws carefully for exempt employees. The EEOC. Employees should be selected for furloughs and layoffs based upon their job responsibilities, without regard for any discriminatory practices. You cannot issue a furlough or layoff based solely on an employee's race, age, gender, religion, nationality, disability, or genetic information. The NRLA. The NRLA requires union employers to negotiate terms and conditions with the union about the employee furlough. So keep that in mind if you are a union employer. Employee contracts. Employees may have contractual rights to compensation or paid leave benefits. Make sure that the terms and conditions listed in employee contracts do not limit the furloughs. Thank you so much for your attention today. This concludes our presentation. Please contact your TPC Vision team if you have any questions. We look forward to continuing to support your organization. Thank you.